Property Law Alliance. I hope you're all doing well this evening. I'm joined tonight with Silna Stain of SSLR Incorporated, as well as Bruno Samau of Bruno Samau Attorneys. How are you guys doing?
Hey, Rowan.
Hi, good, thank you. Wednesday.
Yeah, always. Thank you guys for joining us tonight. Let's get into it, because I know we have an address coming at 8:30, which we're all looking forward to hearing from Cyril. So let's get going.
I don't think, Bruno, I don't think we've ever been in a position where we open for the president. I think that's pretty cool.
Yeah,
that is cool.
We're the opening act tonight. Although maybe, you know, knowing Cyril, he may be a bit later than 8:30, so we may have to prolong this video for quite some time.
Now, if we could get our viewership to those numbers, that would be fantastic.
Exactly. Okay, first things first, obviously just a quick update on what's happening right now in level 4. A lot of the questions being asked right now is, would one person be able to terminate a lease agreement with a non-paying tenant and get him out of the premises? Where are we standing with this right now? Silna, maybe you want to start us off?
Yes, so now is a good, I'm sorry, I promised there was something flying. I was just losing it. It's not like close to day 50 madness that's hitting me. So, Rowan, I think now's a good time to take the opportunity and to just quickly address something very important, which is terminology. Terminology, especially for property investor, a rental agent, and obviously for property lawyers, but I really hope that most property lawyers got this one down. But just practically around that question, the term termination was used. And I think it's a very important conversation to have, the difference in terminology in starting to using the correct terminology. Why I'm saying this and why I'm hijacking the question to address this is, if landlords and agents already understand the difference in terminology that we are using, we as the attorneys on the end during the eviction doesn't have to first change and correct the terminology that was used in correspondence leading up to the case ending up with us. So there's a very big difference between the terms cancellation and termination. So everybody that's ever been in one of my training sessions knows exactly which analogy I'm going to use now. So, okay, but I'm anyway going to do it. So for the guys that hasn't seen this, termination is the natural end of an agreement. A contract has a beginning and an end. So let's take a lease agreement for an obvious example. 12-month lease agreement starting on the 1st of May, ending on the 30th of April. That is the term of the agreement. When it ends on the 30th of April, that is termination. A month-to-month agreement where the one party gives the other one 1 month's written notice of termination, that is termination. Cancellation is an action to breach. It's a remedy to breach. So remedy in law is used in two ways. On the one hand, you have remedy where you say you are in breach, you haven't paid your rent. You need to remedy that by paying your rent. But you also, as the innocent party in law of contract, you have 5 remedies to your disposal, one of which is cancellation. So cancellation is an action to a breach. And the analogy that I'm always using is termination is like in a marriage, death. It's the natural end of that marriage. Nobody is upset with each other. Everybody is like sad and stuff, obviously, unless the mistress rocks up at the funeral. But other than that, you're not going to have a damages claim or any drama. Cancellation is like divorce. Something happened and this wasn't the planned end of the transaction between the parties. And why this is relevant is when you refer to termination, where the intention is cancellation, usually on termination, you don't have a damages claim with that. Potential damage to the property, which you use your deposit for, but not a damages claim because there won't be a financial loss on termination. But on cancellation, there will be a damages claim. So if you use the incorrect terminology, it could very well cause confusion at a later stage. I know I'm overcomplicating the answer, but I think it's important to understand the difference. Yes. So if the question is, can we cancel the agreement now? Because that was the question. And I took 10 minutes just to get to the actual answer. You can, definitely. And we could have done this even in full lockdown. You could have done a letter of demand, giving the tenant 20 business days if the CPA applies to the agreement, or whichever other time period there is in terms of the lease agreement, to allow the tenant to remedy his breach, so pay the outstanding amount. If he doesn't, you can cancel the agreement. So just before we started, we've discussed this, Bruno. So what we've said is, as much as we can cancel the agreement now, that will place the tenant in a position where the lease agreement is cancelled, which means the tenant is now in illegal occupation. But I'm going to leave it to you to explain what we've discussed around that, because currently, whether the tenant can move or not, so allowing us to evict or not, is a little up in the air. So I'm going to pass the ball to you after I just spent 10 minutes just to dissect the question.
Awesome. Thanks so much, Sona. So the reality is that we're not in a position where we can easily rid ourselves of defaulting tenants. So the reason why we suggest that you take the necessary steps is to get the ball rolling. There are situations, for example, that if notice were given and it was expiring over this next period of time, and for some reason that both you and the tenant had the forethought to be able to negotiate leases and other places of residence, then in those circumstances, you'd actually be able to make use of this period that's been given under the directives to relocate under a lease agreement. But this is where things start getting very, very complicated. So remember, if there's any new viewers that didn't watch the webinar last week, what we discussed then was new directives came out, I believe it was Thursday evening, if I'm not mistaken, that allowed tenants to relocate under very specific circumstances. And those circumstances were, firstly, there's a lease agreement that they concluded prior to the 29th of April, that where they can move into premises under that lease agreement, or before the lockdown, they took transfer of a property that they bought. So in those circumstances, it allowed the purchasers to move into those premises. So what we were saying in those instances was, because no one during the lockdown realized that they could actually sign lease agreements, because no one realized where they could move and when they could move, many people negotiated new tenancies, new places to move into, just with the uncertainty on when that was going to be. But those lease agreements were actually entered into during the allowable time to allow them to move now for the next month up until the 7th of June. So what we were saying was, if you record those agreements with the correct dates when you negotiated the agreement to begin with, you'd actually be allowed to move leading up to the 7th of June. So now we move to the question. Again, so 10 minutes I spent trying to explain something just to lead myself to the question.
We are being such lawyers tonight. What is this?
Yeah, typical attorneys. Typical attorneys.
So now when it comes to this question, what can we do for a defaulting tenant? First of all, you can place them on terms. That effectively means that if you send out a letter now in terms of the CPA, you're probably already outside this period that I spoke about now anyway. So any action happening right now in terms of the CPA, which generally is the case under residential lease agreements, where it's you contracting with not a company, you're probably contracting with a normal individual. If you send out a notice now, at best, you get the ball rolling, because as soon as the 20 days is up, you can start the legal process. So you won't be able to evict the person from the premises, but at least you can start the legal process. You can start the eviction steps, which will get that ball rolling, and the order might be granted pending only the end of the lockdown, at which point you can execute. If for some reason you gave notice prior to this, let's say you gave notice during the lockdown the level 5 lockdown somewhere in April, for example, and it was coming up very soon or has come up already, there it's slightly different, because if you give notice to force the tenant to vacate and he's had the forethought of making other plans, moving back with his parents or entering to a better lease agreement that's cheaper for him, he can actually move out the premises and nothing stops him from moving out. And it is something that you can push him to do if you're persuasive enough to get him to move out the premises. That's still lawful. I think that
Bruno,
answers the question, doesn't it?
I like it. What we've done, we had a case yesterday that we've discussed in the firm, so in SSLR. So what happened is we had a court order, an eviction order that was obtained already prior to lockdown. And the eviction date that the court said was the 31st of March. So this tenant now, the illegal occupant, didn't vacate, as they do, hence the eviction situation. And the question was, okay, as much as we can't execute our eviction orders now, can we approach the High Court for contempt of court order? And we are going to proceed with that. So we're going to do a test and see how the court reacts, because our case is the tenant knew already from the 16th of January, when the court order was handed down, that she had to be out by the 31st of March. So our argument is we can bring a contempt of court application, because in that window period from the 30th of April until the 7th of May, when people were allowed to return to wherever they came from, they had an opportunity to get out of the property. So we're going to bring this case. So why I'm telling the story is I don't have an answer on how the court will react to that. But I think for our viewers, it's actually a very good case to keep an eye on. So as soon as we have a judgment handed down, I will let I will let everybody know, and obviously you first, Bruno. So if it works, and if the court does see that as contempt of court, at least it gives us a good indication on how the judges will react to us bringing contempt of court applications where we aren't able to send the sheriff out to execute on an eviction.
That's actually really cool. If I was the judge, I would definitely consider the application. And so much of it is going to be based on what the papers say, because I know the one thing with contempt, and I've dealt with quite a lot of applications like this, is the intention of the party. So even though there's a court order, if the party was willingly or intentionally trying to trying to prevent the court order from actually taking effect, that's generally when the contempt kicks in. So in a case like this, for example, the reality is the person was supposed to move out by the 31st, so they should have had plans. They should have made arrangements. So by not making arrangements, as soon as the once off period came in, or as soon as this period now up until the 7th of June kicked in, those arrangements now all of a sudden could have taken effect. And that's the reality. They knew they had to move out by a certain date, and they should have made prior arrangements, which they could have effected now. What may cause the application to fail potentially is if arrangements were made, but for some reason, now they've fallen through due to the lockdown. And as a result, this new period hasn't afforded the person sufficient opportunity or any opportunity to actually enter into a new lease agreement somewhere else. So that might be the only downside, but the upside is they should have done something leading up to the 31st of March.
Yes, exactly. And if like you said, if they can demonstrate that they're not in willful default. So exactly like you said, they've made arrangements, they're trying to get a permit, they can prove that the police refused to issue the permit, cool, then I'm happy that the guy can't move and he's not in willful default. I just want to, sorry, I picked up something earlier when we spoke about lockdown. I just want to clarify something there. Lease agreements concluded before, during lockdown, and lockdown being defined as a time period 1 minute before 12 on the 26th of March until the 30th of April. You mentioned lease agreement concluded before the 29th of April.
Sorry, apologies. Yeah.
Oh, 30th. No,
Yeah,
okay, cool.
yeah.
No, I was just worried because I've been saying 30 April, and I'm like,
Yeah, no, so bear in mind,
okay.
when I think of those regulations, I keep thinking 29 April, 29 April.
I'm
So,
sorry.
yeah,
I just
yeah.
wanted to clarify that. I'm like, I've been giving wrong advice for a week. Okay, so luckily I haven't. Woo. Thanks. Sorry, Ron, I'll keep quiet.
No, no problem at all. It's the whole purpose of this, to discuss everything. While we are on the courts, how are they functioning? Are they actually functioning? Are they working correctly? How is it going with court procedure right now? If any of you have any kind of experience, I don't know, maybe Silna, you have anything to say?
Yes, I think, Bruno, I think we both probably have stories from what we've been seeing. So since Monday, the 4th of May, we obviously level 4 essential service workers. We're so proud of ourselves, eh? Lawyers, yay. So we're obviously practicing again, limited staff in the office and things like that. But life is starting to feel a little bit more normal. Instructions, I must say, we have had an influx of eviction instructions, I must say, way more than what we normally see, especially in May. I don't know if you have the same thing. I must say, usually April and May are instructions for evictions is on a bit of a decline, and it picks up only again in usually July, August, September. And I must say, the amount of eviction instructions we've been getting in the past week is astronomical. My poor attorneys are looking like they've been hit by 17.5 trains. They really dealing with a lot of inquiries, a lot of instructions. I think you're seeing exactly the same thing. Well, obviously Greg is as well. I forgot to pass his apologies. He got stuck in a matter. So this is, I think we're all very busy with eviction instructions right now. But we've actually had our first successful application this morning. We had we have a few matters on the roll now coming up, but we had a matter in court. Claire, one of our associates, had a matter in court this morning for an alternative service application, obviously to initiate eviction proceedings, because while the sheriff can't serve our new eviction proceedings, we need to bring these substituted service applications to serve over email or whatever. I've actually once done a substituted service application to serve over Facebook Messenger. Imagine how surprised you are when there's like this random, I'm going to say it, this random chick sending you a message and you open it and it's a summons. You're like, whoa, I didn't see that one coming. So we've done this, and we were successful with that application this morning. So I think that is absolutely shockingly brilliant news, because it's not an urgent eviction. It's a normal tenant that hasn't been paying his rent, placed on terms, cancelled, and we got our substituted service application this morning. So I'm very excited about that. I think this will open the door for a lot more of these, and Claire did that comfortably from the comfort of her own home. I'm still wondering, she must have been fully robed. I think her dog judged her so hard, like, what are you even wearing today? But it worked, and I'm happy. So what's happening in your firm?
So so we've seen a couple of applications being granted, not necessarily just evictions, but just general hearing. I know that there was a couple of divorce matters that are being dealt with. From an eviction side, we've got a Section 4.2 coming up, so we managed to get the dates. We managed to get dates for that. So it's pretty much the same. The one caution I would maybe give out to the viewers is, now be very careful. It also now depends what attorneys you're using. So we're forced to stay on top of this and constantly be up to date, because this is what we're consistently doing. But what I've noticed is the magistrates' courts are a bit more problematic, because every magistrates' court is being dealt with differently depending on whether there were cases in the court, how the magistrates actually want to deal with it, whether it's a regional court or a district court. And for example, I know that Rambo came out with a whole bunch of directives on how to deal with certain matters. I haven't actually approached the magistrates' court yet, mainly because I'm worried. I'm not sure if they're going to function as efficiently as the high courts. So it's just a heads up. yeah, at the moment, I think my opinion is going the High Court route is probably the more favorable and the more efficient route. I'd be very careful if somebody tries to get a matter in the Madge Court. I'm obviously not referring to other things like rental collections and things like that, because those generally you'd want to run through a Madge Court. So I'm referring more to the eviction side of things. Stick to the High Court. Yeah, I'm a bit worried about the way Madge Courts are handling things.
Interesting question. So I just want to explain quickly what the 4.2 notice is, but because I have a question for you. So the 4.2 notice is the notice in terms of Section 4.2 of the Prevention of Illegal Evictions Act. This is how you know this is eviction lawyers talking to each other, which is like 4.2. Everybody knows what we're talking about. But the 4.2 notice is the notice. It's an ex parte. You bring an ex parte application. That means one party brings the application to ask the court to authorize your form of your 4.2 notice and a service directive. And the service directive that we usually get is that the document must be served, the 4.2 notice must be served on the respondent in person or somebody older than 16 at the premises. So now my question, Bruno, is, now I'm going to steal your brain here. What are you asking the court? Are you asking for a specific service directive? Like, are you using the opportunity to get an alternative service directive? Because with the sheriff not being able to serve the 4.2 notice, are you going to try and get it already on a substituted service?
Absolutely. So we've got a couple of matters. The one, we're fortunate enough for there to already be attorneys on record. So the 4.2 is simply just goes to the attorneys. So that's normal service of a document. But to answer your other question, if there's no attorneys on record, absolutely use the opportunity, because you can. And you go in there and you try, ask the court for any form of substituted service, any way that you know you're going to get the documents to these people. And it's kind of a strange one, because I was thinking about this earlier. The sheriffs are refusing to do services, for instance. But I know, especially as attorneys that are functioning, we do have access to, for example, 2 permits to drive around. Would that entitle us, for example, to go to a property and affix it to the gate? Can we ask the court to allow us to do this without the sheriff's intervention? Or, you know what, the sheriffs may say that they're not going to do it, but can we ask the court to, in any event, order the sheriff to do it during this period of lockdown? And would the court actually entertain that? That I'm not sure, but I'd probably list them all as alternatives. So yeah, throw it and see what sticks. And
I like it.
Yeah.
When's your matter on the roll? Just for fun.
Sure. I don't remember.
But it's gonna only been about a month.
Yeah, sorry, I don't remember the date at all. I just remember somebody telling me it's they got a date. Yeah, I know that the dates actually weren't too bad. So somebody served a notice of set down on me for a Rule 4611 for one of my distressed property clients, and they served it at the end of April, and the date was on the 18th of May.
Sure, that's quick.
So yeah, I don't know how that happened.
Okay, but so lucky, we have quite a few matters in court between our firms, which we can update our audience on, which I think is going to be beautiful. I think we're going to see lovely law coming out now.
Then, guys, while we're on the topic of acts, the Property Practitioners Act, what exactly is happening with this? Silma, I don't know if you want to just give a quick, brief update on it's been thrown around quite a bit on a few groups. Just want maybe if you could just clarify the situation.
Yes, so I am the one attorney that will always say I will never ever train or say anything about an act until he is officially promulgated. So the problem with the Property Practitioners Act is a true story. We've seen the publication, we know what's happening, but the regulations hasn't been promulgated yet. And so I'm going to use the example of the regulations on the lockdown regulations. So we saw the initial draft regulations on what level 4 will be. People thought they're going to be able to smoke. We already saw in the draft regulations production of wine. Rowan, I know for a fact you and I had this conversation. I'm like, oh yay.
Definitely.
and eventually the published and gazetted regulations looked very different. So everybody was like, oh man, government is lying to us. No, it was in draft form. The fact that we believe that draft form is gonna be the regulations, unfortunately, that's not the way legislation works. Legislation is only really there once it has been promulgated, it's been gazetted. So the draft regulations for the Property Practitioners Act has been published, but it's been published for public commentary, which means it's exactly like the level 4 surprise we got on the regulations. People read this, they interpret this, they think it's going to be the way the law is going to be. And because there is public involvement, this is, I know this sounds like a huge surprise, but this is what democracy is all about. Citizens has the right to give some input into the legislation. So while it's still open for public discussion, please, 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 guys, don't think that relations to the Property Practitioners Act will be the actual gazetted regulations. And I don't want to talk about something that's not gazetted because it's not real yet. It's like, Bruno, remember the good times when on the 15th of November 2015, the Rental Housing Amendment Act was published. It still hasn't been promulgated. Every single estate agent I know have sat in training after training after training about the Rental Housing Amendment Act. It's been 5 years and it still hasn't been promulgated. There's an amendment to PI that was published in 2005, guys. I was still studying when that happened and it still hasn't been promulgated. So I don't want to talk about something that hasn't been promulgated. And to be quite honest, I want to caution everybody on doing that, because I got so many calls today. Are we sure that estate agents will be allowed to function in level 2? No, because those draft regulations isn't real. So I'm mixing the regulations for the lockdown with the Property Practitioners Act regulations for a very specific reason, to illustrate my point. Am I being dramatic again, Bruno?
No, look, the analogy is important, and I get why the questions are there, because people want to try plan ahead. And it is kind of unfortunate that we aren't able to plan ahead because we never know what's coming. These regulations now, with COVID, really emphasize this issue, because literally the regulations come out overnight and the next day everyone's running around. And at best, what we saw that government was trying to do is they gave us a heads up over a media briefing or a press conference about 5 days before, trying to tell us, okay, look, this is what we're thinking of doing, just to kind of prepare you. But the reality is, no matter how many webinars we did leading up to that final regulations, those are all for naught, because then all of a sudden there was a whole range of stuff introduced that we had to go back now and try and rectify. So it's the same thing with most regulations, with most legislation. Remember, under normal circumstances, there's normally also periods to comply, sort of transitional periods. So with COVID, obviously it was very exaggerated because it happened literally within a period of a few days. But with most of the legislation, people will receive notice. They will be allowed a period of 6 months to a year to 2 years to 5 years to make sure that everything's in order. So the reality is the preparation time will more than likely be there. So why spend our energy focusing too much on it now? Know what's there, know what's probably going to be there, but don't maybe take it further than that.
Great, fantastic. Then also another question that's coming up quite a bit is, what if you have cancelled your lease agreement, but now the tenant is staying in the premises and due to the regulations, they can't move out? What type of right of recourse does the landlord have in this instance? Is it a damages claim? What exactly is the landlord entitled to? Silna.
Yes, so this is a question I'm getting quite often. So it's a sad question, and most of the times it breaks my heart to give the answer, because the answer sounds potentially unfair. But it depends on which side you're looking at the question, and which side you're looking at the answer. So the simple answer is the tenant that cannot afford to pay his rent in this time, and the tenant that knows he won't be able to make up for it, so a deferred payment isn't an option for him, he has to cancel the lease agreement. The landlord that doesn't have the ability to allow the tenant a deferred payment, or whatever the situation is, the long and the short of the story is the tenant can't afford the rent, and the landlord doesn't have an obligation to allow the tenant to stay in his property for free. It's as simple as that. So that tenant has a right, in terms of Section 14 of the Consumer Protection Act, to cancel the lease agreement by giving the landlord 20 business days notice of the cancellation. The landlord is then entitled to claim a reasonable cancellation penalty from the tenant. And that reasonable cancellation penalty will either be dealt with in the lease agreement. So the parties will agree, for instance, the tenant will then pay a 2-month cancellation penalty, keeping in mind that cancellation only occurs on the cancellation date, not on the notice date. So the time that the tenant is still in occupation of the premises, the money that he's paying for that occupation is towards occupation, not towards the penalty. The penalty then happens only on cancellation. So he has to pay his rent up to that point, and then pay the 2 or 3 months cancellation penalty that the parties agree to in terms of the lease agreement. The landlord, however, when the lease agreement is silent on this, the landlord is entitled to claim the actual damages that he suffered. And this is in terms of the Conventional Penalties Act. Conventional Penalties Act, all the way from March 1962, it's been a while, has been exactly the same, unchanged, and not in contradiction to the CPA. It says you're not allowed to claim a penalty higher than the actual damages suffered, but at the same time, you are allowed to claim your actual damages suffered. And so the landlord has an obligation to mitigate his damages, meaning you have to advertise the property, place a new tenant as soon as possible, especially after all of this, and the property, the rentals will adjust and correct and be reduced. The landlord will have to potentially reduce his rent just to get in line with the market conditions to allow a new tenant. But currently, that landlord isn't able to show the property to prospective tenants, so the landlord is by law unable to mitigate his damages. So unfortunately for the tenant that cancels now, in terms of Section 14 of the CPA, will be liable for the full damages that the landlord is suffering, limited obviously to the amount that the parties agree to in terms of the lease agreement. And unfortunately, it will very often drop the tenant in a worse off position, because now he's going to cancel the agreement. He has to move out as soon as he can, but he's going to have to pay the damages to the landlord until the landlord can place a new tenant, and who knows when that would be. So my recommendation would be, just discuss this with the landlord. Don't just enforce your rights right now by cancelling. It could very well be worse off for you than to just enforce the rights rather than having a conversation with the landlord.
Yeah, absolutely. Agreed.
Is there another way a tenant can approach this, Bruno, or is this is the only option, eh?
Yeah, look, it's very difficult. If the tenant can't afford to pay, so aside from the compromises, deposit utilizations and all of that, if they need to get out of the lease, you'd be lucky if your lease agreement actually does limit the damages, because normally when we looked at 2 or 3 months damages, we thought, oh, that's quite high, because a tenant would be able, a landlord would be able to place a new tenant in a month and a half, 2 months. But now 3 months actually sounds pretty reasonable and would actually be in favor of the tenant now as opposed to the landlord. So that would limit the amount of damages that that the tenant would be liable for. But short of that, if the tenant needs to get out of this lease, the best suggestion I would have is if there are people out there that are looking for other accommodation, even if they can't move and they start negotiating leases, at least give the landlord a heads up, let him start marketing the property, even help him market the property with visuals and virtual tours or whatever, and let somebody else sign a lease to move in when lockdown is over. And as soon as that happens, be ready to move out so this guy can move in. And but unfortunately, up until then, get into some sort of compromise with the landlord. But yeah, legally, Section 14 is pretty much the only way to properly cancel.
Great, thank you so much, guys. Then also there is a document going around called a disclosure document, and it's being asked, how will this be handled by rental agents? Would one of you be able to just explain this document and how rental agents will be able to use it?
Isn't that part of the promulgation to the regulations to the Rental Housing Act?
Is it okay? So that was just what we spoke about earlier with regards to it hasn't been promulgated yet.
Exactly.
Okay,
the disclosure form, the only other potential disclosure form would be in terms of a sale, in terms of the Consumer Protection Act. That's the only other. So in that situation, if that's the question, it wouldn't refer then to a rental because it's then irrelevant. The only other disclosure form that I can possibly think of is in terms of the regulations, unpromulgated regulations to the Property Practitioners Act.
Yeah. So maybe just one topic before we close off. I don't know if there are any more questions, but there is one topic that I'd maybe like our viewers to think about and maybe pose questions so we can answer it next week. I've had a lot of cases, I don't know about you, Silna, but I've had a lot of cases now recently where all of a sudden, and it's difficult to say, so I don't want to say it's vultures because some people actually do care, but there's certain individuals that are inciting, what's the best way to describe it? So they're basically trying to convince tenants that rental isn't payable, especially in terms of especially like residential leases. Now, we spoke about this previously, that there was a Facebook group that was trying to justify this, but there wasn't any legal basis for it. Now we're starting to find other groups that are actually taking fees and subscriptions from tenants and then trying to come up with these notions of, oh, but you don't need to pay. Oh, we'll do this. This is fairness. And I've seen the emails that they're sending out. And I thought, you know what, it's once off. I actually mentioned it during our little chat with Greg, you saw. But then today I got another one. So somebody was actually trying to lay criminal charges with the Victims Enforcement Unit or Victims Protection Enforcement Unit with the SAPS. So I'm still waiting. I didn't even know there was a unit that was, but now we're still waiting to see what the outcome of the meeting there was, because my landlord went there and went to meet with them. But there seems to be now this move towards that sort of environment, which is dangerous because the reality, like we explained before, is rental is due. And there's nothing in our law that says otherwise. Even the president himself has encouraged the payment of rentals. You might just land up with a judgment against your name and having paid a subscription fee to someone that wasn't ultimately able to help you at all, just to get evicted anyway. And all you've really achieved is frustrating the other side into making them less likely to be, or less amicable to resolving things with you. So I'd be very careful, but if you're a landlord, maybe pose some of the questions so we can have a look and just see who's out there and what they're actually saying.
I'm glad you said it. Luckily, I haven't seen any of those. I've seen those level 5 full lockdown rental housing tribunal things in the Western Cape and in Gauteng, which says you can't be evicted. And it does refer to, the one I've seen refers to you don't have to pay rent. It can't possibly be real from the rental housing tribunal. There's no way that it wasn't even a full lockdown thing. So be very careful, guys. There are so much nonsense out there. It's really shocking. And I think what's scarier, Bruno, is people see this, they believe this, they don't pay rent, And what I think people don't appreciate is when you get evicted, it's not like you're just going to get an eviction order against you and you then have to move. So it's basically like, okay, I'll give up then. You're going to have a cost order against you. And without talking too much about cost, but we've taxed out on an unopposed eviction, we've taxed out to over 20,000 Rand, even on attorney and client scale. It's huge amounts of money, and you can really end up as the tenant believing that it's fine, I will leave when there's an eviction order. You need to understand that with that eviction order, even if the landlord lets go of the rental claim, there will be a cost order involved. And the thing is, the effect an eviction has on your credit record is not pretty, because remember, all the evictions then also sit on the TPN system. So next time you want to rent a property, you can't tell the landlord that, no, you know what, I got evicted, it was like that one unfortunate incident. It means the landlord now knows that you're stuck in that property until the sheriff had to come and kick you out. It's really not pretty. It's not a good idea to wait to get evicted. I don't think we have a lot of people on our group that will get evicted. I think we're playing on the other side of the field,
No,
but
fair
still,
enough,
just for funsies.
So that's why I'd love to hear if people are struggling with any tenants that have come up with stories like this, just so we know what's out there, what to kind of expect, how to even address it, because if it's causing trouble, rather deal with it now and actually put it out there and then see what kind of reaction we get.
I like that, and I like I want to invite everybody to post questions during the course of the week. Post the weird things that you are seeing. Just say, I'm posting this for discussion on the Wednesday webinar, because we obviously can't be on Facebook the whole time. We have actual evictions to do. So unfortunately, we can't answer your questions afterwards, but we look at the questions, we record it, obviously, and then we address it in the Wednesday webinars. So please, 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 guys, like Bruno said, post all the weird and wonderful things. Just make sure when you post one of those potential fake news things that you clearly say, I just want to get your opinion on this, so we don't accidentally spread false news on the Property Law Alliance group.
Awesome, yeah.
Absolutely. Definitely a great group now, especially since you guys have now given all of our members some homework for next week's webinar. But great, that's all the time we do have for tonight. Thank you so much, Silna and Bruno. There's a lot of comments going on today saying thanks for great content, good advice. It's a very informative session, so really thank you for tonight. And again, guys, comment, question, post any topics you want to discuss in the group, and we can discuss it next week. And we will then see you next week. And obviously, with anything that happens and any regulations that are let go tonight by Cyril during his address, we will, as soon as possible, yeah, we might see you tomorrow morning.
I think what we're going to see tonight is going to lead into potential something only being issued tomorrow. So we could see you tomorrow morning, we could see you on Friday, or we can see you next Wednesday. We really don't know.
Yeah, we can't confirm. Thank you so much, guys. Appreciate it.
Cool. Thanks, Ron.
Thank you. Thanks, guys. Cheers.
Cheers.